Well, good afternoon, everybody. My name is Matt Cruz. We're happy to join you again. I have Per Oscarrson and Sarah Smith joining us. We're going to be talking today about the use of powers of attorney in estate planning. The title of our presentation, Avoiding Guardianship, really comes from the idea that when you're using a power of attorney to appoint a decision-making agent, you're really, by doing that, avoiding the need for guardianship. Okay, so let's talk a little bit about guardianship and let's set the context here a little bit. Sarah will be presenting first, discussing powers of attorney and some of their key elements, and then Per will have some specific comments and information for us about some important specific powers issues under the power of attorney. So when I meet with clients, I am typically referring to powers of attorney as a method of privately appointing a guardian, instead of the guardianship process, which I refer to as a public appointment of guardian. Here's what I mean. A public form of guardianship involves going to the court, asking the court to appoint a guardian, and often a guardian ad litem. Guardian ad litem is an independent party who's charged with investigating a situation and preparing a report. They file with the court to recommend the scope of guardianship that's required. The general rule in guardianship law is that the court is to impose the least restrictive or the minimum amount of guardianship if guardianship is appropriate at all. And so what do I mean by that? Well, there's a concept of full versus partial or limited guardianship. When somebody needs a full guardianship, it's said that they need help with decision-making regarding their personal and healthcare and with management of their assets and finances. Implied in all of that is the possibility that a more limited form of guardianship is appropriate. Sometimes people are able to, cognitively able to manage their own medical decisions or personal care, but they're not as capable of managing their assets or make their own financial decisions. In those cases, a limited guardianship would be imposed. In fact, the legal standard is the court impose the least restrictive or least broad form of guardianship necessary under the circumstances. And often the court is informed from two sources. One is the guardian ad litem, an individual who's specifically trained and appointed by the court to conduct an investigation into the circumstances in order to recommend a full or limited guardianship. And then there's the petitioner, the one seeking the appointment, the one who sees the need for guardianship, asking the court to appoint them as the alleged incapacitated person's guardian for purposes of decision-making. Now, implied in all of this is the individual, the alleged incapacitated person, is not able to make their own decisions or all of their own decisions. So if an individual has failed to execute a power of attorney where they've indicated who they want their decision-making agents to be, then we need to submit to a guardianship process in order to make healthcare, personal care, and ongoing financial management and transactional decisions. But when an individual has executed durable powers of attorney, and either Sarah or Per will talk to you about what a durable power of attorney is. When someone has executed a durable power of attorney, they are privately appointing a guardian, in effect. They're giving somebody the authority as expressed in the instrument of appointment, the authority to act. And there are limitations on those authorities. I think Per is going to address some of those. So by executing a durable power of attorney, you're taking control of who your guardian would be, in essence. By signing the document, you're privately appointing essentially a guardian, likely eliminating the need for the public form of guardianship. Let's talk a little bit about the process of the public form of guardianship because I think it'll help you understand why you should be taking control of these decisions for yourself and executing durable powers. In the common garden variety guardianship process, paperwork gets filed with the court at the beginning of the process. A guardian ad litem is selected and appointed to conduct the investigation. The guardian ad litem needs some time to do that, usually around 60 to 120 days. And then a return hearing is established once the guardian ad litem has produced and filed with the court its report recommending or denying or defining the scope of guardianship their investigation suggests is appropriate. A return hearing then, approximately 90 to 120 or 150 days, is established, and it's at that return hearing 3-4 months after the process has started where the court is then being asked to appoint the guardian. When the court does appoint a guardian, they direct the clerk of the court to issue letters of guardianship, and it's those letters of guardianship that the guardian is able to give to third parties, whether they be doctors or hospitals or banks or other financial institutions, so that those third parties can rely on their legal representative authority. So I would estimate that the typical guardianship, assuming it's uncontested, costs $3,000 to $5,000 or so. Takes about 90, 120, maybe 150 days. Now, there's some circumstances where the process can be sped up for emergency type issues, but we're talking about a fairly expensive process, a fairly time-consuming process, and we can avoid all of that. And it's also a public process because this is a court action. There's a court file. Now, to avoid all of that, as I'm suggesting, we should be thinking about executing powers of attorney. As estate planning lawyers, we often think that executing or experience at executing powers of attorney are just as, if not more important than actually executing wills and trusts for the disposition of our estates. So with all of that as background, let me turn it over to Sarah. She's going to talk to you a little bit about what a power of attorney is and some of the basics, and then Per will have some specific comments following Sarah's presentation. Sarah?
So Matt, you just made a really excellent point, which is that a lot of people come in thinking about wills and trusts, and we've all heard the joke about death and taxes, but the planning for incapacity is such an important part of what we do here. I'd like to share a couple of facts with you just for context. The Alzheimer's Association estimates that approximately 1 in 9 people aged 65 and older has Alzheimer's dementia. And the National Institute of Aging says that up to half of all people age 85 or older may have some form of dementia. So when we're talking about planning for incapacity, our hope is that you never have to use these documents or worry about them. But the fact is, it's a far more likely outcome than people may be giving consideration. So since failure to plan can lead to these lengthy and expensive guardianship proceedings, as you discussed, the durables provide an alternative solution. Establishing durable powers of attorney gives somebody the permission to act in your stead if you lose capacity to act in your affairs. They literally have the same impact if they act on your behalf as if you acted for yourself. By enacting these proactively, you can protect and choose who acts for you, guide those decisions, and help protect your quality of life when you're not able to do that for yourself. By the way, you will hear that person will be referred to typically as the agent or the attorney in fact. Both are more or less interchangeable depending on the document you're using. Also, I refer to the durable power of attorney for medical decisions and for financial decisions as separate documents. That's how I prefer to draft them. You may see them in a combined document. Some attorneys do prefer to draft it that way. Neither is necessarily wrong, but I prefer to draft them separately in case it makes sense to use different agents, be more specific about powers that they're allowed, et cetera. I'll go into that more in a moment. It's also important when you're looking at these to remember that, or to understand that we call them durable because they survive incapacity. And not necessarily every document does that. If you've done estate planning previously, you may have a power of attorney presently that may or may not account for incapacity. And so when you're coming in for an appointment or reviewing your own documents, those are things that should be reviewed to make sure that it's actually serving the purpose that you want it to. More limited power of attorneys are sometimes used for granting someone the ability to act on your behalf in a business transaction while you're traveling or something of that nature. So not all of these documents are the same. They're very customizable with either broad powers, more limited powers, and really should be approached with that in mind. So when people come in and sit down and we start having this discussion about what your power of attorney should look like, one of the first things that we're going to discuss is, who do you want to act on your behalf if you are not able to act on your own behalf for whatever reason? And the first thing that a lot of people think about is their spouse, their children, the people around them whom they love. And we're going to ask, my dear spouse to act on my behalf. And if she can't, then or he can't, let's just go down the kids in order of oldest to youngest, or we'll let them all work together so that nobody feels left out. And that is a beautiful thought. But in practice, it's important to remember that the person acting as the agent is fulfilling a job. And that job has technical requirements and skill sets that some people may be more or less suited towards. The person who's acting owes you fiduciary duties, which means that they must act in accordance with your reasonable expectations if they've been expressed or if not known in your best interest. They must act in good faith, and they must act within the authority granted by the power of attorney. Loosely speaking, they owe you loyalty. They should act with due care, competence, and diligence. Seems very simple, but you might have somebody like my dear friend who I would trust in any hospital situation that you can imagine. If there's a medical problem, she's on top of it. But if it comes to doing math, not so much. So she's not the person that I would appoint to make financial decisions for me. That would be somebody else who's more capable of handling those tasks and those responsibilities. So in addition to who has the skill, what's also, do we want to have one person, multiple people? Generally speaking, if you have a single person who is capable of fulfilling that role, it's wonderful because it is clean, simple, they have the full authority to do what needs to be done, and they can manage your affairs efficiently. In some situations, a person may feel that it is better to have multiple people. Either they don't want to express favoritism, there are concerns that one person may not have sufficient time or skill or some other desire for checks and balances. That is not wrong, but it does create complexity and a potential for conflict. And unfortunately, as some of you may know, conflict is a source of expense in many legal issues, if not most. Anything that you think can be simple can be blown up by conflict. So when you have multiple people acting together, are they acting by majority? Unanimous decision. Even if you have everybody working well together with clearly designated powers and paths, what are the institutions going to require? Because remember, these documents give someone the power to act on your behalf with others. So are they going to accept one person coming in and acting on your behalf? Are they going to require all five or all three or what have you? So all of these things are worth considering. Is it worth the added complexity or the risk for conflict to have the benefit of these additional people? No? Maybe we go back to looking at a single person. Don't trust a single person to act alone? Maybe we need to revisit who the people are that are acting for you. Again, it's not a one-size-fits-all conversation, but these are thoughts to bear in mind, particularly if you're getting ready to start your estate planning, to be prepared for this conversation. In addition to picking who's going to act for you as your initial individual, also it's good to have successor individuals in line or indicated in line to step up if something happens to the first person. they're not available for whatever reason, you've got 2 or 3 others who can step up and make sure that there isn't a lapse of care. In addition, and not something that people necessarily think about, but this is also a great place to nominate who you would want to be a guardian if a guardian becomes necessary. Now, clearly the goal of all of this is to avoid having to go through a guardianship proceeding, but let's say the individual in question has started developing dementia and paranoia as a result, and now they're convinced that the person who is designated to help them is in fact out to hurt them. It might be that the court still decides we're going to start a guardianship and we need oversight. But at least in this instance, they will typically respect the person that you've nominated. And so you'll still be able to know that the person that you want to take care of your affairs is the person doing so. And I will say this many times, and you will hear this many times in all of our lectures, but as your life changes, as the situation changes, these are also documents that should be updated to make sure that the people that you have designated are still the people who are available to act and are the people that you would want to act. The next question is, when should your power of attorney become effective? Your documents can be drafted in such a way that they are effective immediately. And by immediate, I mean when you sign on the page. Conversely, they can become effective upon a future date, typically incapacity. It can seem wise to wait until incapacity. You don't want to give power. You don't want to invite risk. But unfortunately, capacity is not always a bright line judgment. If somebody's in a coma, it's fairly clear that they're not capable of managing their affairs and that somebody needs to step in accordingly. But if someone's beginning to develop dementia, for example, it can be much more difficult to determine when they've lost capacity, or with something like dementia or medical treatments or other chemicals, people may move in and out of incapacity. It can be incredibly difficult to nail down at what point that document should become effective, if that's the standard. Forgive me. So it's, meanwhile, while that person is going in and out of capacity or developing incapacity, you're trying to, prove it. You're trying to get access to documents that may be protected by HIPAA and go through all these different steps. That person might be refusing treatments that are in their best interest, making poor financial decisions, signing documents, and otherwise engaging in behaviors that can put them at risk, or they may be susceptible to abuse from other persons in their lives. And so that lapse of time, yes, you have that additional protection of requiring proof of incapacity, but a lot of harm can happen in that time. And that brings us back again to that conversation of the agent. If you're concerned about trusting your agent while you're healthy, will you trust them when you're unable to understand or oversee their actions and what they're doing? No? Might be worth revisiting that conversation about who your agents are going to be. In addition, if you have documents that are set to become effective upon incapacity, again, going back to that conversation of third parties, what they require to prove incapacity could be a letter from a doctor. It might be that they want a court order. They can require reasonably speaking, they can require what they want to prove incapacity, even if the document that you draft says, no, you don't need a court order, because they're concerned about their own liability. So it's, again, that other layer of time and complexity and expense.
Excuse me, Sarah, I have a question.
Please.
So if you're recommending that the authority granted to the decision-making agent be effective immediately, doesn't that create an opportunity for that agent to make decisions that the principal wouldn't agree with or wouldn't want? Is there some conflict of interest that you're establishing when you create the authority to make decisions immediately?
Well, so that goes back to the fact that this is a job that comes with fiduciary duties, particularly of which are the duty to act with the principal's expectations or in their best interest. If that person goes off the rail and decides to empty a bank account, one, banks are not going to make that easy at all. they're going to absolutely verify with the principal if someone comes in to wipe out a bank account. A doctor is always going to work with the principal if they can do so, even if the only way of communicating is by blinking your eyes. But in addition, because of those fiduciary duties, if they breach that duty and act against the principal's interest, your interest, they're in for a world of trouble, litigation, etc.
Yeah.
It is not an unfettered key of access.
When I face this question with my clients, all that you've said is correct, but I often remind my clients that this is an agency relationship, and in an agency relationship, the agent doesn't have the right to override the knowing, able decision-making of the principal. So the principal remains in control of their own decision-making, and the agent therefore does not have the ability to legally contradict or act inconsistent with what the principal would want. So in addition to the fiduciary responsibilities you mentioned, where the principal's interests are supposed to be paramount and the agent is legally prevented from acts of self-interest, for example, taking money from the principal, etc., as long as the principal remains cognitively in a position of making their own decisions, third parties will look to and be held accountable, really, to act only on the principal's decision-making. It's only when there's a demonstrated inability, even though the agent has the immediate authority to act, they don't have the practical ability to act unless the principal is unable to make the decision for themselves. So if there's a conflict under an immediately effective power of attorney between the decision of the agent versus the decision of the principal's decision prevails, as long as the principal has sufficient capacity to be making their own decisions.
Correct.
Okay.
Correct. So, and that brings us back to the conversation of which is best. Do we want them to have to prove incapacity, or do we allow them to be effective immediately and trust the people that we're working with and trust the process? And I have two answers to that, and it depends on which document we're talking about. When we come to the durable power of attorney for healthcare decisions, frankly, my recommendation is always to have it effective immediately. If you are in a situation where there's a medical emergency or something of that nature, the weight of proving incapacity or the lapse of time that it may take to go through all the steps, a lot of harm can potentially happen to someone during that time. And as you say, clinicians and the others, they are absolutely going to work with a person, with their patient directly in as much as humanly possible. Regarding financial decisions, good fences make good neighbors, but proving incapacity, as we've said again and again, is time consuming and expensive. And as you pointed out, institutions are going to banks, and forgive me when I say institution, I'm referring to banks and title companies and all these sorts of people who your agent would be interacting with. They're very invested in working with the principal directly, the person directly. And so having that requirement of proving incapacity just tends to be layers of complexity and difficulty where if you trust your agent, it's often not worth it. It's just a lot of trouble. But with the healthcare power of attorney, that lapse of time can be difficult. With business, there may be time to act around it. So speaking of acting, what do these actually do in practice? A durable power of attorney for medical decisions, as it implies, gives your agent the power to make medical decisions for you if you can't. This can be a doctor, a dentist, an x-ray technician. Anything that requires care for you while you cannot do so for yourself, care of your person. This should be somebody who, as we've said before, has the skills to handle that situation. This should also be somebody who knows what you would want. medical care is not simply a question of what will be the most effective treatment to cure an illness. It can be questions about religious preferences and moral preferences, preferring to have more invasive treatment or less invasive treatment depending on the situation. It's very important when you're creating this to think about what you would want if a medical emergency or long-term medical care or end of life, and communicate those things to the people that you've asked to be your agent, and have conversations about that to empower them to know what you would want and help to understand if something comes up that you haven't discussed, what you would have wanted had you had the chance to have that conversation.
Sure.
And
So, excuse me, Sarah. So, Per, I have a question about the specific powers that we grant in each of these powers of attorney, either the medical or financial. Do we really have to express every single power that we want our agent to be able to exercise? Couldn't we just, wouldn't it be good enough to say, well, the agent can exercise all authority or decision-making power or function that I would have as if the agent were the owner of my assets? Can you talk to us a little bit about issues that come up in terms of granting the specific authority for your agent to act in these situations?
Sure. And I'll go to the next slide. Generally speaking, durable powers of attorney are very broadly written and use that language or something similar to what you just said about the agent or the attorney, in fact, being able to do whatever I could do if I was present and capable of doing it. That's kind of the purpose of the very broad language in comparison to the guardianship, which would generally be, although you recognize that it should be as limited a guardianship as appropriate under the circumstances, but it may need to be very broad. Same thing holds true for the power of attorney. However, the state of Washington, and I'm sure there are several other states that have done the same thing, have said, regardless of the language in the power of appointment document, there are certain powers that, unless they are specifically granted, your attorney, in fact, does not have. And on the screen right now, I've put up 10. The statute actually deals with about 12. Only one of them is really in the healthcare decisions. That's a specific one. Maybe the reason for having a separate financial power of attorney from a healthcare or medical power of attorney, you can specifically say healthcare decisions and make that still very broad, because whether fortunately or unfortunately, at the moment the document is signed, you probably have no idea what's going to be involved at any point in the future, and what kind of decision might be involved, or what kind of condition might be involved. The rest of them tend to be on the financial area, and these are things like a trust during your lifetime, an inter vivos trust, otherwise known as one that's created during your lifetime. There, the state says, well, if you want someone to have the power to create one, or revoke an existing one, or amend an existing trust for you, you have to specifically provide for it in your document. Same thing with gifts. The ability of your attorney, in fact, to make gifts of any kind does not exist unless that language is in the document. And typically, we would have some sort of language that would also provide some additional guidance to the attorney, in fact, as to, well, what kind of gifts? Are these gifts that are limited by the federal annual exclusion, currently $15,000 a year to each potential recipient? Or is it something where a gift of significantly larger value that might involve preparation of a gift tax return, maybe payment of gift tax, although that seems probably less likely for the vast majority of people given the federal exclusion amount for gifts. But that should be in there as well. What kind of guidance are you providing, as well as what group of people are you including in gifts? Are you limiting it to maybe just family members? descendants? How extensive is the family? Could it be cousins, nieces and nephews, first cousin once removed, something like that? Or is it broad enough to include your history of having made gifts, to include various types of charities or specific charities that you have given to over the years, and what kind of amounts have you given over the years?
Excuse me, Per.
Yes.
Per, you've used a phrase. I just want to clarify for everybody. You've used the phrase attorney in fact. Can you remind us what does that mean and who is that? I often consult with people and they say, well, I have the durable power of attorney for so-and-so. Just remind us a little bit about who do you mean by attorney in fact?
Well, the attorney in fact is the person who has been granted the power to act on behalf of the principal.
Okay.
They may go by other terms as well, like we talked about agent. We use that here in differentiating between the financial attorney in fact and the healthcare attorney in fact. We talk about the healthcare agent. But that terminology, I think, is really almost irrelevant. It's just a way of distinguishing between two different people, but their powers, they still have the powers that have been granted them under the respective document.
Okay.
Rights of survivorship. You can hold property in different types of ownership. As an individual, you may hold it just by yourself. You may hold it with someone else. Well, maybe that's community property. It may be a joint tenancy with right of survivorship. But being able to create or change those, that's something that would have to be specifically provided in the document. Beneficiary designations would tend to be things like bank accounts. Certain bank accounts may have like a payable on death or transfer on death designation. So in the paperwork that creates or modifies that account, there is a designation of a beneficiary. Again, that's something that has to, if you want to grant that power to change that beneficiary, you've got to have it in the documents. An attorney in fact sometimes may need, for whatever reason, or may want to delegate some of their authority under the document. Without language that specifically allows them to do that in the document that grants the power of attorney, the attorney in fact cannot delegate any powers. Now, this is limited in that there may be certain things that an attorney in fact is unable to do for whatever reason, and they delegate to someone else that authority to do that, provided that that delegation authority is in the power of attorney document. But they're not allowed to delegate all of their obligation or all of their duties. They can kind of basically pick and choose if they're going to do that. Even though they delegate, they were still going to be held responsible for the action because of their delegation. They haven't delegated the responsibility, they've delegated authority, and there's a difference.
I see. Hey, Per, I've got a question.
Yep.
So for the client who comes to us, how do they know when they need powers of attorney? And, we've talked about specific powers here. It seems like there are a whole lot of different considerations here. How does the person coming to us know what's appropriate for them?
I think, well, for the financial part, certainly we have our form uses a number of paragraphs that just give examples of powers that they're there, whether the power is there, whether it's in the document or not. And I think it's not so much for, or it hasn't been in my experience, so much for particular things like dealing with real estate, maybe dealing with financial accounts. It's more of an understanding on the part of the client that there may come a time, even if you're not incapacitated, where you would like to have someone act for you. And unless you've granted that power to someone, nobody's going to have that ability to act on your behalf. I think some people certainly are concerned, well, what if I do become incapacitated? Then what happens? And then there's the discussion about, well, if you haven't become incapacitated and you don't have a power of attorney in place, even if it's to be effective only upon incapacity. Then if you do become incapacitated, then we're looking at the guardianship, and how extensive is that going to be? How long is it going to take to do it? What's it going to cost? So I think it provides people, when we talk with them, because I very often have people say, oh, I need to get a will. I'll ask them too, have you thought about a power of attorney? Oh, what's that? And we kind of go into what that is and why we would suggest having it and having something in place. It's certainly not required, but it can certainly make things easier for potentially a number of people down the road if something were to happen to the principal.
So as I indicated earlier, if someone engaged in estate planning does not choose to execute durable powers, then they suffer through injury or illness, an event of incapacity. The only way to get somebody or have somebody make some medical or financial decisions, pay bills, et cetera, during the period would be through the appointment of a guardian and that public process I outlined earlier. Is that right?
Yes. Yes.
Yeah. So let me ask you this then. It sounded like the whole consideration of planning for incapacity is part of our normal estate planning process. These are issues that we raise with the clients to see if they're interested in executing these kinds of documents, engaging in this kind of planning.
Yes. Yeah, absolutely. Because
Yeah.
they may not have thought about it, because practically everybody has heard of a will. A lot of people have heard of trusts, and some say, hey, I want to get a trust. Well, we talked about why would you do that, but then the same thing is they haven't maybe not thought about who could act for them, because they may assume, for example, that a spouse can act for them if there's no document in place. And I think probably more in the medical field, if there is no power of attorney in place and it's a spouse, for example, that is they may be asked to make a decision if there's in the absence of a guardianship or the absence of a power of attorney. But if it's potentially an adult child of the individual, they may not be in that same position, and they may not be viewed the same way by those who are trying to get a decision. So I think having these in place, again, whether they're effective immediately or they're effective only upon incapacity or disability, having that in place with people that you trust to make decisions that you would, if given the opportunity, would probably make the same decision, or at least you trust that they are going to think about this, because they may have to make a decision that you may not want to make on your own. But under the circumstances presented at the time, if you've picked a person or persons, whether it be multiple attorneys, in fact, and 2 or 3, for example, for financial decisions, or 2 or 3 for healthcare decisions, you've picked those people that you feel comfortable will make a decision after really considering what's in your best interest. Then I think that provides a great sense of relief to people. Still hoping that they may not ever have to rely on that, but at least knowing, oh, I've taken care of that. That in itself can help relieve some anxiety.
Sure. So it sounds to me like everybody can rest assured if they need estate planning, we would certainly talk to them about planning for the possibility of their death, but the powers of attorney don't affect that. Instead, the powers of attorney affect or answer the question, what happens should I become incapacitated? And how do decisions get made? How do my bills get paid, et cetera? The planner has the opportunity in advance to control who those decision makers are by executing the powers of attorney. It's not that bad decision makers would be appointed through the guardianship process. It's just you don't have any control. It's whomever chooses to come forward and seek appointment and convinces the court they should be appropriate decision makers for the incapacitated person. So if if the planner wants to exert some control over who would manage their financial affairs and versus who would manage your medical affairs, it sounds like the best way to do that is through executing durable powers of attorney.
Yes.
And as some of our discussion and questions have implied, these are certainly issues that we're prepared to discuss with you as part of the normal estate planning process. You don't need to come with any specific knowledge or list. We are prepared to help explain the benefit of executing durable powers of attorney, explain the complexities of appointing an agent, what considerations you should keep in mind as you're designating who your decision-making agents are. We're prepared to help you think through whether the power of attorney should be effective immediately or upon incapacity. Though it's our recommendation generally that the powers be effective immediately, certainly not improper for you to make a different choice. And we'd be happy to talk you through those considerations, as well as what Per has suggested, the various express authorities that must be presented in the document for the authorities to exist. So in any event, I see our time is nearing an end. Do we have any questions presented? If we don't, we can wrap up.
I don't think I saw that there were any questions.
Okay, no questions then. Hopefully, for those of you who have tuned in, you found this helpful. If you've got any questions, please feel free to contact Per, Sarah, or I. We'd be happy to answer your questions, and we'll close this presentation. Thank you very much.